The next case set for argument this morning is City of Akron versus James Bachtel. That's case number 29-168. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve time, just let me know. And of course, we've got the clock on the wall now, so you can keep an eye on that periodically to know where you're at as far as time goes. The argument says both of you know are recorded, so we ask that you keep your voice up. We've read the briefs and are prepared to proceed if you are.
Thank you, Your Honor. Good morning, Your Honors. Brian Grummer on behalf of the City of Akron. I would like to reserve 5 minutes of my time for rebuttal.
Very good, thank you.
I'm going to try to keep my remarks brief because the matter before you is not a complex one. This is the most recent case involving the statute 2925-11B2B, which is known as the Good Samaritan Immunity Statute. This case here arises from the trial court dismissing the drug paraphernalia charge against Mr. Bachtel on the basis of 2925-11B2B.
What do you think the purpose of that statute was? What was the legislature intending to do when it passed that?
I think the legislature was trying to encourage people to call 911. I think that was the intent with that, and I think along that line they made sure to provide some coverage to people who have drugs on their person, that they would not be charged with low-level drug possession offenses. But
is it that narrow? Drugs on person? Do you think it's that narrowly drawn?
It is, Your Honor. It is. We know it's that narrowly drawn because the legislature defined it as that narrowly drawn. The legislature said specifically that the immunity that's provided under 2925-11B2B is for minor drug possession offenses. Those are defined in 2925B2A4 as violations of this section that are misdemeanors or felonies of the 5th degree. That is, the drug paraphernalia is not a violation of 2925-11. It is a violation of a different section of the Ohio Revised Code. Therefore, it is not a minor drug possession offense. It's defined in this section. Therefore, it is not covered by the immunity statute. It is that simple. And the legislature also made sure to come out almost in the other direction. In 2925-11B2E, it said explicitly that this immunity provision under B2B should not be construed in any way to limit the admissibility or further investigation for crimes that are not minor drug possession offenses. So it actually explicitly carved out the fact that if it is not a violation of 2925-11, that is a misdemeanor or a 5th degree felony, nothing can be construed to stop the admissibility of the evidence or the investigation of those crimes and those offenses. And again, drug paraphernalia does not fall within the definition of 2925-11B2A4 for minor drug possession offenses. And that is this court's obligation to interpret the statute as the legislature wrote it, not to insert words or delete words or phrases, to try to change what the legislature could have said or could have meant. And in this case, the legislature was very clear about what it meant. It made a policy decision, and it had to draw a line somewhere.
What purpose is served by that policy? I understand the purpose that's served by the Good Samaritan policy.
Mm-hmm.
What purpose is served by, okay, you can't get charged with the drug, but yeah, the paraphernalia you can get charged with. I struggle with that. Assuming you're correct in the strict reading, and yet the legislature specifically left that in, far be it from me to try to think of what the legislature means when they legislate. What I would like to think that they have a specific reason, and I'm struggling with what purpose is being served there.
Well, the purpose that's being served is that drug paraphernalia is inherently a misdemeanor. It's not a 5th degree felony, so you're not getting charged with an actual felony charge there. Also, the line has to be drawn at some point in these at some point on these calls, like, because otherwise, you either have, there's always some example that you can come up with and say, well, in these circumstances, wouldn't it be fair to have that be the case? That's a lot of debate from App.No is around the idea of, well, you could have 5th degree level of like LSD, heroin, and there's a parade of horribles in there about what you could have in your possession and be immune, but you're not immune for the drug paraphernalia. But that's equally true of if you have 0.9 grams of heroin, you're immune. If you have 1 gram of heroin, you're not. Like, the line has to be drawn at some point, and along those lines, is that 1/10 of a degree, like, what's the purpose of drawing the line to 1/10 of a degree? It's just the fact that you have to draw it somewhere, or else every single charge in the Ohio Revised Code is going to be subsumed into this. And they made the decision to draw the line where they did. But I would even go further and say that drug possession itself, it probably carries a stigma with it. With having that on your record, there's a stigma to drug possession that isn't associated with drug abuse instruments or drug paraphernalia. Like, that's not that you see those on the charge. That could easily just be a high schooler who had a bomb. Like, and that's not the same. And that people don't have the same like reaction to drug paraphernalia as they would to a possession charge. That could easily have been what they were thinking. But anything along those lines is pure speculation and goes beyond the plain language of the statute. Because I don't know why they made the line where they did, but they made the line where they did. And that's the reality of the situation, is that they're the ones who set the policy, and they are, we are all kind of bound by what the policy decisions they made were in this case. And in this case, the policy decision was that it's only for the possession of the drug, not for the possession of unrelated, of the instruments or the drug paraphernalia.
Can you remind me what our decision was, and I think it was State versus Brown,
Yeah.
and if it's, how it applies here, if it does. I know it was a similar type case.
It involved the same statute. It was that it had involved drug paraphernalia and drug abuse instruments were the underlying charges in that case. And this court held that the statute itself was not ambiguous, that 292511 B2B was not ambiguous, and it also specifically held that the definition of minor drug possession offense was not ambiguous, and that there was no room to engage in statutory interpretation in the statute because the language is plain and unambiguous and there's nothing to interpret. So that was the holding in Brown. And the city's position is that Brown is dispositive of this case, but we also recognize the fact that Brown was decided before the trial court issued its decision in this case, but we still think it's a dispositive decision by the court, and this court
And it's a
should
different
apply.
panel. I mean, you have a different panel for this one, right?
Slightly, Your Honor. You were on the previous one with Judge Schaefer and Judge Conlon. But nevertheless, it would be I believe it is still, it's still a decision I think has presidential value and should be applied. And I would just reiterate the fact that the issue here, and this is really the issue that I feel that Applee is struggling with, is the fact that they disagree with what the General Assembly did. They disagree with what the General Assembly drew the line, and the solution to that is not to have this court go in and rewrite the law to correct this supposed error by the General Assembly. The solution is to go down to the General Assembly and have them amend the law, amend the statute. And until they do that, the limitation of immunity is limited only to possession of the drug, not to possession of drug paraphernalia or drug abuse instruments or any other charges that are outside 292511. And if there's no further questions, I will reserve the remainder of my time.
Okay.
Trial court dismissed this in like 24 hours.
I don't know that the turnaround was. There was a hearing, I believe, on this issue.
This one?
Yes, there was a hearing, and this was also there's 2 other cases pending currently before this court. Pasco and Perry are the names of the defendants in those, and it's the same trial court judge. And so basically the parties involved were the same prosecutor, same defense counsel, and same, yeah, so it's a very, I would not read anything into the time,
Okay.
the speed at which he made that decision. I think it was understandable, especially under the circumstances here.
Everybody was on board, okay.
Yeah.
What was that second case? Perry and?
Robert Perry and, I can't remember the females.
I think it's Brandy Pasco.
Yes.
They were consolidated cases, and they were argued together and briefed together.
Okay. You got 5 minutes and 17 seconds. Do you want to reserve 5 minutes?
Yes, Your Honor. Thank you.
Very good, thanks. All right, Manovsky, you've got 15 minutes.
Thank you, Your Honor. May it please the court, for the record, I'm Susan Manovsky, the Legal Defender's Office, and I represent James Bachtel in this case. And first, I do just want to comment on a couple of questions. I think somebody had asked about the panels on the previous case. Judge Callahan, were not on the Brown case, that was Judge Carr. But I think both you and Judge Teodosio were on the Pasco and the Perry case, so.
Well,
If
how does
this-
Brown apply to this case then? I mean,
Well, Your Honor, I respectfully ask this court to consider invoking en banc and have everybody look at this issue and rule on it with all of the benefits now of it having been briefed 3 times. There are many issues to consider, and the absurd results issue was not raised in the Brown case specifically in front of you, so Judge Schaefer did not have the opportunity to consider that application. And that would be appropriate. I know it's very rare and maybe not welcome, but this is a particularly unusual law. And this law, when it was passed, at the same time, the General Assembly passed Revised Code Section 128.04. That makes this unique. This isn't your typical statutory construction or even your typical absurd results. This law is specifically designed to the overdosing person. And we know that because under 128.04, every municipality is mandated, must train their 911 operators to respond to these calls and tell the caller about the immunity. That is unheard of. So the 911 operator must describe the law to the caller for the sole purpose of inducing the caller to say, come to my house or my location and rescue me or the person I'm with, and we have drugs. That's what the immunity is for. It is only for use. It has never been contemplated or argued that anybody is going to call 911 and say, I have a bunch of drugs at my house. I'm afraid something might happen. Can I have immunity for you to come take my drugs and not prosecute me? No, this is not a possession immunity. It's not a trafficking immunity. It is use. The only way somebody uses drugs and overdoses on drugs is with drug paraphernalia and drug abuse instruments. That is why this statute included the term chapter. So this immunity is to apply to all minor drug possession offenses in the chapter 29. That includes drug paraphernalia and drug abuse instruments. Otherwise, the statute would have simply referred to this section. With respect to the absurd result, just to be clear, you do not have to agree that this statute is ambiguous in order to find that the city's interpretation leads to an absurd result. An absurd result is appropriate in statutory interpretation. In fact, it's the only reason we ask appellate courts to review and interpret statutes. It's because the plain meaning and the plain word application has led to such an absurd result. And that's what distinguishes this case. We're not looking, if you were to just look at the plain words, you would apply this to a mere possession case that did involve an overdose. Well, that wouldn't work, because in the statute itself, the person has to be overdosing. There are several criteria. They can't be on probation. They can't have done this before. They have to seek help for a drug use problem, because they are at risk of dying.
I have a question
Yes.
for you there. If there's conditions on whether this statute would apply or not to any individual, who would make the determination as to whether or not those conditions were met?
The
arresting
prosecutor.
officer?
The prosecutor's office, because that's who grants the immunity.
But if you can't be charged, you can't be anything, then how would the prosecutor ever even get the case to begin with?
I agree that that does not make sense, and I'm not going to defend the way that that law is written, because that is a problem. It's the cart before the horse.
You can't expect the officers on the spot to make those determinations. They wouldn't have the time to.
Exactly. Furthermore, one of the requirements is the person seek treatment, and the prosecutor can demand proof of that at any time.
But there has to be some way to
To
get.
review it,
Right.
yes. As a practical matter, the prosecutor can always dismiss, so if the person is charged. But does that really affect what the statute claims? Because the statute's claiming it's an immunity and you can't be charged. So you have a lot of ambiguity there that has not harmed my particular client. And so I'm not raising that ambiguity, but it's in the statute.
If the intent of the legislature was to encourage people to call, and that you're not gonna be charged with possession of the drugs, and you're not even gonna be charged with possession of dangerous instruments, anybody can call at any time if you're overdosing, will come get you, will save your life, and there's no consequence of any kind.
And that's what was published to the public. That is
So
what
how
we,
does that, how would that encourage the public policy of saving people's lives? If there's no consequence, then just, how would that encourage people to stop using drugs, or do you not care?
this immunity may not stop anyone from using drugs. This is one step in saving lives. So this immunity is targeted solely to saving lives. I'm not going to pretend that by finding the way I'm asking you to, we're going to stop people from using drugs. But if we can't keep them alive day to day, then we've defeated the whole purpose of the amendment. So the converse is true, though. The fact that there's immunity is not going to encourage people to use drugs. Drug use is one of those offenses that we've created. It's not like murder or theft or something that's inherently wrong. Consuming food, drugs, alcohol, substances is a natural thing to do. And we as a society have decided to regulate it for our own safety and the Commonwealth. But when somebody does it wrong and they abuse a drug, it's not in order to harm some other segment of the society or to get something from somebody else. They're doing it because they're in pain. That's what needs to be addressed to eradicate the drug problem. This particular immunity is designed just to keep people alive and encourage help in an emergency, which is why the statute directs the 911 operators to be involved in publicizing what the immunity is. The 911 operator tells you, don't worry, you have immunity, you're not going to be arrested or charged, please give me your location. Well, now we have a Fourth Amendment violation, because that 911 operator works for the state. And they've just induced you to have the police come to your house. Did I answer your question, or did I
To
just?
some
go on?
degree.
Okay.
I guess the underlying question is, I asked you in the first place, which is, if you're not charged with anything, then how are you able to establish that this is your first time or your 15th time?
Right. Yeah, it is procedurally nonsensical.
The worst part would be if the law went away completely, and there was no immunity.
That would be terrible. We are not asking for that.
I understand, but the fact that it's so confusing, I guess,
Correct.
is an issue.
It is confusing, and it reaches across other chapters in the revised code, and it specifically uses terms like chapter and section, which is why the drug paraphernalia and drug abuse instruments that are used to abuse the drug and potentially overdose on the drug has to be considered part of the statute. Otherwise, it's absurd.
So you're saying you could read it to include drug paraphernalia?
Yes, I think you can read it to include drug paraphernalia because drug paraphernalia is in
It's in the
chapter
chapter.
29. And the immunity talks about using drugs. It's not narrowly tailored to just possession. The statute itself, or the immunity itself, addresses drug use, not just drug possession.
I was looking at 12804, and
Yes.
it does instruct the person who answers the phone to inform them about 292511.
It does.
292511, but it say 12, 13, 14, anything else, it just says 11.
Correct. That
And
is,
11 is only possession of controlled substances.
that is where the immunity is in that section. That is true. And in the section A of that same statute, public safety answering point personnel shall receive training in informing individuals who call about apparent drug overdose for the immunity from prosecution. So what kind of training are those 911 call operators receiving?
Because it specifically refers to 292511, wouldn't that be?
And the language in 292511 refers them back to the chapter, which is chapter 29, which includes the other sections. I thank you very much for your attention. If there are no other questions, thank you.
One second, Judge Callen. Okay, thank you very much for your presentation today as well. 5 minutes.
Thank you, Your Honor. First, I do want to apologize to Judge Callahan that I was wrong, that you were not on Brown. Attorney Minosky is correct about that. Another thing I want to briefly touch on is the idea of the en banc. En banc is only for resolving inter-district conflicts, and as there's only one case so far, there cannot be an inter-district conflict on this issue. So that is not right. That is not right before this panel. The issue about the idea about there being ambiguity in this code section, to the extent ambiguity exists, it does not exist about what crimes, what offenses are covered by the immunity. The immunity very specifically is limited to minor drug possession offenses. Pursuant to this chapter, which is the phrase that defense counsel repeatedly tries to rely on, does not modify minor drug possession offenses. It modifies the list preceding it about not being arrested, charged, prosecuted, or convicted pursuant to this chapter for minor drug possession offenses. Pursuant to this chapter does not modify what offenses fall within minor drug possession offenses. There's no ambiguity about what actually falls within the scope of the statute. To answer a question that Judge Schaefer has been, you asked about how would you know this person is qualified or not. One of the things that you need to do is you need to actually be screened as part of the process. So until you're actually screened, you couldn't qualify as a qualified immunity. So like if you're arrested at the scene, you're not qualified yet. And when you're potentially charged, you wouldn't be qualified yet until you actually go to get the screening that's required. So that once you get the screening, then you'd be qualified, and then the immunity would kick in. Whereas if you were screened beforehand and then it was known, then you would probably not be able to be charged or arrested. But until that happens, they would not be a qualified individual, so the statute wouldn't really spring into being for them. And the other issue I want to point out is, although Applee consistently says that this is about people getting treatment, you don't have to get treatment. That's the reality of the statute. You don't have to get treatment for drugs. You only have to get screened for treatment. But there's no requirement that you go, there's no requirement that you do anything. And so the statute itself, it does not actually engage in any way of actually assisting people get off drugs. It's a very low hurdle for them to clear. The other issue is about the 911 operators, the idea that the 911 operators having to, they have to make reasonable efforts to inform people about the immunity provision. And what is very clear to me when we listen to the idea of like, well, it shouldn't just include drug possession. It should also include drug paraphernalia. It should include other drug abuse instruments. It should, like, it starts getting, once you start adding things, it's not clear where the line is. It almost becomes a case-by-case basis about what is and what isn't included in the drug paraphernalia. What if the drug paraphernalia is unrelated to the drugs that you overdosed on? What if it is a marijuana bong versus like the baggie that the heroin was in that you overdosed on? Like, why is that covered? Is that covered? Is that not? And that's the reality of it, is you would never be able to train the 911 operators to be savvy enough to go through all these different possible scenarios. It's the drug itself. You're immune
On
from
the
the drug.
constitutional implications, so of a 911 operator convincing somebody to let the police officers into their house, under the theory that they're not going to be arrested.
Well, first of all, the Fourth Amendment issue is not before this court right now. It was not decided by it was not reached by the trial court, and so this court typically does not decide things in the first instance. Having said that, I am not sure what kind of Fourth Amendment violation there could be. You're allowed to mislead people, and to the extent that this even could be considered misleading, that's still not a violation of their Fourth Amendment rights. They're not under arrest. They're not within police custody. They're not giving. They are calling someone, and they're speaking to someone on the phone. If they get misinformation from there, it's not a Fourth Amendment violation. It's there's no violation in that case. And so this is an issue that, again, it's not before you, but I don't see how I do not really see this being a legitimate position to be taking about the idea that this is somehow violating people's constitutional rights. Like I said, like if a police officer comes to your house and says, like, hey, I need to use your bathroom, and they don't need to use your bathroom, you let them in, and they see things, like, it's still, you still get to, like, you can still be charged with everything, and that's not a Fourth Amendment violation. So,
Well, your time's up. So.
thank you, Your Honor.
Thank you very much for your arguments. Both of you, thank you for your presentations. We'll take the matter under advisement and issue a decision in due course. Of course, you will receive a copy of the decision in the mail. The clerk will mail it to you on the day it's released. And as you both know, the opinions are also posted on the Supreme Court of Ohio's website. Very interesting arguments. Thank you.
Thank you.